All right. The court calls 24-02051Y, People versus Robert Schroeder.
Very good, yeah, people.
Here by special appearance, Your Honor, remain in honor and not to argue but to challenge authority.
Your name?
Chauvin Robert Lewis.
Okay. This is the date and time set for a preliminary exam. Mr. Chauvin appears here on his own. As we've done in the past, Mr. Chauvin, I need to make sure you understand your rights today with regards to the potential to be represented by counsel. We've had this conversation before, correct?
I do not consent to any statutory authority presumed by this court.
Okay. We've had that conversation before about your right to have an attorney?
I am representing the all caps name, Your Honor. I am the attorney.
Okay. Do you want to have an attorney assigned to you?
No.
All right. You understand that if you wanted to, the court would have the Michigan Indigent Defense Counsel assign you.
I understand that.
Okay. You understand also the challenge of the crime that you're charged with?
Yeah, I don't understand that.
The maximum penalties? It's a felony charge of non-sufficient funds check that occurred on or about May 31st, 2024. Maximum penalty is up to 2 years in prison and a $2,000 fine or 3 times the amount payable, whichever is greater. You've heard all of those maximum penalties before?
I have.
You have any questions about that?
No.
And having heard those maximum penalties, is it your request today to proceed on your own without counsel?
Yes.
Okay. You know that I have to treat you as if you had an attorney, correct?
Yes.
Okay. You know that I can't assist you in any way as we go through this hearing. You're going to have to question witnesses on your own. You make the decision on whether or not you want to testify. You understand all that.
I do.
You do? Yes. Okay, you do. But I won't be able to help you with that.
Right.
You understand that? Okay. Have you ever gone through a court hearing previously?
No.
Okay. Have you looked into what a preliminary exam entails and exactly how this is going to go procedurally?
You briefly explained it to me last time we were here.
Okay. Do you have any questions right now about the process?
Well, my first question is, my question really regarding the whole thing is, I don't know if she is,
Who's she?
the prosecuting attorney is capable of even speaking in this thing.
I'm not sure if that's what you mean. My question was about a preliminary exam. I'll let you can make your motion here in a moment if that's what you're getting at, but do you have any questions about this preliminary exam?
No.
Knowing all that, all the understanding and explanation that I just gave you, your decision today to proceed on your own.
Yes. Yes.
All right. You want to bring up a couple issues?
Yes, I have an issue with the fact that under the bankruptcy of the United States of America, does the prosecutor have bonded fiduciary or sworn trust? Does she act as a prosecutor with bonding and act as a trustee for the United States? So is she able to do that?
Are you asking me a question?
Yes.
Okay. I'm not going to answer any questions. You have a motion that you want to make or challenging something and
yes,
saying that the court should move in one direction or another. I'll make a decision on that.
I would like to make a motion to challenge the validity of the prosecutor being able to prosecute this venue.
Based on what? I'll give you. Based on what?
Based on the bankruptcy of the United States of America.
Okay.
Because is she a trustee for the United States of America? That is my motion.
All right. Ms. Lee?
Thank you, Your Honor. Your Honor, I'm a licensed attorney in the state of Michigan. I am employed by the County of Oakland, and I have authority to exercise my prosecutorial duties within any district court within the County of Oakland. Furthermore, Your Honor, this charge is not anything that has been charged federally. Otherwise, there would be a federal prosecutor here. This is a county level from the city of Berkeley. So yes, I do have authority to move forward with these charges because the charges did come from my office, which is at the state level.
All right, and I've reviewed the complaint prior to today's hearing. It complies with the Michigan court rules and statutes that are at issue. Mr. Chauvin, you've made an objection. It's been being recorded on the record. The court's denying your objection, denying your motion. Have another motion you want to make? Are we ready to go?
Yes, I also have a motion for denial of process, that this should not even be taking place because I was denied access to documents, records, by making me pay for a fee for copies, which is against the Constitution.
What copies did you have to pay for?
Copy of records,
Which records?
my court filings,
Your court filings?
that I submitted.
You needed copies of the documents that you submitted?
Yes, certified copies.
Did you get those?
I had to pay for them.
Okay.
There should be a judicial notice on your desk.
I have something here with me. Did you get anything?
I did not hear it.
Did you want to review this?
May I approach your Honor?
Any response to what he's talking about?
Your Honor, I mean, with regard to getting certified copies, everybody has to pay for those, so I'm not entirely sure where the issue lies. Furthermore, they're his documents, so I'm not entirely sure why copies were needed to begin with. So I also have nothing to do with whatever fees are issued by the court.
Sure. So those fees are again set by court rule and statute, and you know your objection to the court imposing those fines, or not fines, but fees to get the copies, those are overruled. The court's just following the court rules with regards to that. Your motion is denied with regards to the impact it may have on your due process. If it did have any impact, it would be a negligible one, given the fact that they were the documents that you had submitted. And the court register of actions would just simply confirm that they were actually submitted, which you could have also done by bringing your own second copy, having a true copy made, or a stamped copy returned to you that way. But in any event, I don't believe it has any impact on the way that we're going to proceed today. So again, you made your motion. There's a record of it. I denied it, and we're going to move on to additional motions.
Yes, I have one more motion. I think that this case should be totally thrown out because there was no legitimate warrant, sir.
No legitimate what?
Warrant,
A warrant. Okay.
which is why we're here in the first place.
No legitimate warrants.
No lawful warrant. I apologize.
Before I let you respond, what are your objections to the warrant that they would make it unlawful?
Well, I wasn't notified of a hearing to have the warrant issued, and under law, Public Act 1957, I'm allowed to be at a hearing where a warrant is issued in my name.
Were you denied access to the hearing?
I've never received a notice.
Okay. All right. Continue.
Your Honor, the warrant was issued by the office, it was sworn to by the court, entered into the system. I believe that there is not only case law, but statute, Michigan law, that allows for that to occur without having the person being charged present.
I agree. I'm gonna again deny your motion. You made a record of it though, and that's the court's ruling. So any additional?
No.
All right. Then everyone can have a seat. And did you want to call your anything from you?
Yes, Your Honor, I would just ask for a mutual sequestration. I'm not sure who this individual in the court is.
Okay. Who's in court with you?
This is my wife.
Okay. Is she a potential witness in the case?
Your Honor, is this Kimberly Chauvin?
Yes.
She's listed on here as a witness, so I'd ask that she be sequestered as well.
Okay. Any comments about that request?
She kind of helped me with counsel though, so.
Okay. She can't do that. She's not. Is she an attorney?
No.
Okay. So she can't do that. So that's not a basis for me to deny the request. So the reason that we'll have everybody step out on both sides, so any of your witnesses except for the officer in charge would also need to be out in the hallway, is that all the testimony will then occur and no one will be able to hear it and have that influence the way that they're going to testify. So on that basis, the motion to sequester witnesses is granted. So Ms. Chauvin, you'll need to step out in the hallway and we'll get you when it's your turn to come to testify. Okay? All right. Your first witness.
Thank you, Your Honor. People call Matthew McBride.
All right, so before you get seated, if you please raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth. I do. Put your hand down and have a seat. Once you do get seated, if you state your first and last name and provide the spelling of both for the record. Jeez.
This.
Sorry. Well, Tony's.
Sorry. Matthew McBrien, MATTHEWMCBRIEN.
Go ahead and say you.
Thank you, Your Honor. Mr. McBride, where are you employed?
Credit Union 1 in Berkeley.
And is that located at 28845 Woodward Avenue?
Yes, it is.
You indicated that's the city of Berkeley? Okay. And what is your job?
I'm a teller.
And what are some of your duties and responsibilities as a teller?
Handling transactions mostly, but I also do some I count the ball if the managers are going and stuff like that.
Okay. And how long have you been employed there?
5 years, a little over 5 years.
I'm going to draw your attention to May 31st of 2024. Were you working that day?
Yes.
And are you familiar with a Robert Chauvin?
Yes.
Did you see him in the courtroom here today?
Yes.
Can you please point to him and identify something he's wearing?
I guess a pale shirt.
Thank you, Your Honor. Let the record reflect that the witness has identified the defendant.
Without objection, the record is ordered.
Did he come into the bank on May 31st?
Yeah, I came through the drive-thru.
Just do the drive-through,
Yeah.
okay. And why was he there?
He was there to deposit a check and then make withdrawals.
Okay. And I'm showing you what's been marked as People's Exhibit 1. And Your Honor, let the record reflect that I'm handing copies of all People's proposed exhibits to defendant.
So,
May I approach the witness, Your Honor?
you may.
Thank you. Please take a look at that. And is that a copy of the check that was provided to you on that date?
Yes.
Did he also provide a copy of his ID?
Yes.
Your Honor, I am showing the witness People's Proposed Exhibit 2. Your Honor, may I approach? Is that a copy of the ID that was provided to you?
Yes.
Your Honor, I move to admit both of People's Proposed Exhibits 1 and 2.
Any objection, Mr. Chauvin?
No.
All right, records are so admitted.
Thank you, Your Honor. Now, when someone comes through the drive-through, is there a camera or can you see them?
Both. There's cameras and there's a big window.
Okay, so how were you able to see Mr. Chauvin?
Through the window. Yeah, I think he came through lane 4, which is pretty clear view.
And once he provided copies of the check and his ID, what happened next?
So he did, I handled deposit and then he wanted to do multiple cash withdrawals.
Okay, and what were the amounts of the withdrawals, if you recall?
Honestly, it was a long time ago. I don't recall the exact amounts.
That's fair, isn't it?
Yeah, but I think there were like 4 or 5.
There were 4 or 5 withdrawals?
I believe so.
Okay.
Which was a regular occurrence with his transactions.
Okay, so you've been to that credit union before?
Oh yeah, many times.
Okay. And did you provide the withdrawals to him?
Yes,
And how were they provided to him?
in envelopes, like
Okay,
different denominations.
okay.
Usually asked for certain amounts in separate envelopes, so
And it was cash?
yes.
So the check that was provided to you, what was the amount on that?
It was 30,000.
30,000. I'm showing you what's been, I'm going to mark this as an exhibit, but you did write a statement in this manner, is that correct?
Yes.
Okay, and with reviewing that, refresh your recollection regarding the amounts of the withdrawals?
Yeah, if I put them in the statement.
Okay, you're on Mayor?
You may.
Okay, and how many withdrawals were made?
7.
Okay, and what were the amounts of the withdrawals?
So one for $1,024, $960, $1,500, $600, $1,200, and $2,000.
Your Honor, I have nothing further for this witness. May I approach for the exhibits?
You may.
Thank you. Okay. And Judge, may I publish to the court? May I approach?
Mr. Chauvin, you have the opportunity to cross-examine this witness.
I have no questions.
All right, Mr. You may step up.
Thank you.
Before you get seated, if you'd raise your right hand. Solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes.
Put your hand down and have a seat. Please state your first and last name for the record and give the spelling.
Jillian Taylor, GILLIAN TAYLOR.
Ms. Taylor, where are you employed?
Credit Union 1.
And is that in the city of Berkeley?
I used to be the manager in Berkeley. I'm now at St. Clair Shores, but I was, yes.
Okay, and That was back in, May of 2024, you were the manager there?
Yes, ma'am.
Okay. And what were some of your duties and responsibilities?
Managing the branch daily, managing the staff, making sure everything is running.
I'm gonna drop to September 5th. Did you contact, of 2024, did you contact Berkeley PD?
Yes.
Why did you do that?
Our risk management department sent over a packet to send down to them. So when they do that, they just send it to the branch manager, we call and hand that over.
Okay. And what was the purpose of that?
It was, from my understanding, it was because bad checks had been passed and was causing us a loss, so they were sending that down.
And do you recall the name on the checks that were passed?
Sure don't.
Okay. And the person who had deposited those checks, were they notified to your knowledge?
I believe so, yes.
Okay.
Objection, Your Honor, that's hearsay.
Your Honor, if he was notified, she's branch manager, she reviewed everything. It's for effect on the listener, not for the people that are asserted.
Overall.
Thank you. And when someone is notified of that information as a general way, how do they get notified?
By phone and by mail.
And to your knowledge, was their mail sent in this case?
Yes.
And would that have been, how would that have been sent by mail?
That would have been sent through our risk management department, so it wouldn't have been anything I touched or saw.
Okay. You didn't see it either?
Nope.
Okay. Can we have a moment?
You may.
You provide a packet from your loss prevention to Berkeley PD?
Yes.
So you gathered everything up and gave it to them?
Yeah, so they send me the packet complete. I don't actually.
So you just, okay.
Yes, I just hand it over.
Okay, thank you. Your name?
All right, Mr. Chauvin.
All right, thank you. Thank you, Your Honor. People call Detective Hatfield.
I did raise your hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yeah, sure.
Seek your first and last name, spelling both for the record.
It's Detective Lieutenant Andrew ANDREW Hadfield HADFIELD
Thank you, Your Honor. And where are you employed?
with the City of Berkeley Public Safety.
And in what capacity?
Currently assigned to the Detective Bureau.
And how long have you been employed in that capacity?
I've been an officer for 21 years and a detective for 12.
And were you assigned to this case?
I was.
What was the first thing you did once you were assigned to this case?
I was assigned a case with the documents, so first part was kind of going through the documents that had been turned over from the bank.
Okay, so you reviewed that in its entirety?
Yes, what was turned over to me.
Okay, and who was the suspect that was developed in this case?
A Robert Chauvin.
And in that packet, what information was present?
There was documents from the bank showing the transactions in their ledger. There was a picture of his ID, a copy of the check, witness statement, letters that were sent to Mr. Chauvin, copies of documents to, I think, try to correct the bad check or the non-sufficient fund check that they had received. Or top of my head, what I can remember was
Okay, I'm showing you what's been marked as People's Proposed Exhibits 3 and 4. Your Honor, may I approach?
You may.
Please take a look at those. Is that a copy of the letter and the return that was sent to Mr. Chauvin?
So Exhibit 3 is a letter that I had a copy of. This is very common, what we've seen from the bank in all of our past cases that shows the intent to collect on a non-sufficient fund. So that's item 3. That's what I saw in this case and kind of other cases. Exhibit 4 is a certified mail receipt, which is the same thing we use whenever we send it out to Robert Chauvin. That was signed, it's like August. Those are kind of documents that we got included.
Thank you, Your Honor. I move to admit People's Proposed Exhibits 3 and 4.
Any objection?
No objection.
All right, so admitted.
Thank you, Your Honor. And once you reviewed everything, what did you do next?
I had also received video from the bank, so I reviewed the video. The video appeared to match the ID of the person that they turned over to me, as well as I believe there was a account or a phone number for the account. So I did call that phone number and spoke with the gentleman who identified himself as Mr. Chauvin.
Okay, and when you spoke with that person who identified themselves as Mr. Chauvin, what, if anything, did you learn?
He stated that he had been trying to deal with the bank in regards to this check. He stated that he had made the deposit of the check, had withdrawn the money, and then had attempted to work with them through a, trying to think of the term of the document, but he had turned over the document that was trying to pay or be a promissory note for the funds. He said the bank wasn't accepting it. He did mention that he had some documents or video I asked him to turn over to me, which I didn't receive, and basically said he had attempted to deal with the bank. So that was kind of a conversation in regards to that.
Okay, and when you said that there was a form that he was trying to deal with the bank specifically, would that be something called a bill of exchange?
That was the word I was looking for, thank you. The bill of exchange he had mentioned, which was within the packet that we had received, that he had given to the bank. When I asked him about it, there was conversation that he had attempted to call the bank, but the bank provided a 1-800 number, so he couldn't contact him there. He said he had dropped that off to the bank, which is how I presume the bank had a copy of it.
Okay. And would the bank accept that?
I was told that they did not.
Okay. So what, if anything, happened next?
I mean, pretty much from that point, we had submitted for records to confirm that the account that the check was written from did not have the funds. So we submitted that, I believe it was Chase Bank, showing that the account did not have the $30,000 in it at the time that the check was deposited into the bank.
And to date, has Mr. Chauvin reimbursed the bank for those funds?
Not to my knowledge.
Thank you. Your Honor, may I approach for the exhibits?
You may.
May I publish the report? Could I have nothing for this?
Mr. Chauvin, any questions for the detective?
Yes. Sorry. On the date we spoke on the phone, did you have any intent, or did you think I had any intent to fraud the bank?
Objection, Your Honor, calls for speculation.
Same.
All right, I have no more questions.
Lisa.
No, you're correct.
Mr. Chauvin, you have any witnesses you were calling today?
No.
All right. Will you be testifying? And ask to find over?
Your Honor, people who provide over charge of any argument for a vote.
Mr. Chauvin, any comments about bind over?
Yes. So to bind over is to go to circuit court, correct?
Correct.
Okay, so I do have one question. In my attempt to cure debt, I attempted to deposit a bill of exchange, which is lawful, and they rejected it. So why is that not taken into consideration here?
Okay, so your argument is that you tried to cure the debt, and so for those reasons, the case should not be bound over.
Yes.
Okay.
Your Honor, I would just indicate for the record, you did testimony that the bill of exchange that was presented by Mr. Chauvin was indicated to be not accepted as tendered legally to the bank. Furthermore, Your Honor, that's a question of fact for the trier of fact.
All right. The court's heard the testimony from the witnesses today, the arguments of the parties. I find that the testimony provided by the two witnesses from the bank and the detective do meet the probable cause standard required at the preliminary exam to bind over this matter to the circuit court. Mr. Chauvin brought up a potential trial defense. That's an argument that you could make later on down the line. But as of today, that is a question of fact and whether or not that was an actual legal tender that you had provided. And it's not a basis to deny the bind over. So that's something that we'll continue to move on down the line here. I find that the testimony met the burden So count one is bound over to circuit court for further proceedings, and 5